So next is my turn. I'm Liu Qiao, a professor at the City University of Hong Kong. In my presentation, I just want to make a few points about how the CISG can be extended to Hong Kong. So I'm not going to say a lot about why the CISG should be extended to Hong Kong. I think it has been said happening in the consultation paper. All the justifications I echo with the legal and the economic justifications. But there is one aspect which I will return in a minute. But my focus will be on how to implement, how to extend the CISG to Hong Kong. I think there are three general issues which maybe are not confined to this particular question, the extension of the CISG to Hong Kong, but it may have more wider significance. The first illegal issue is about the treaty interpretation. How do we interpret an international treaty? Particularly here, we are looking at Article 93. And the question is, can we extend the CISG on the ground of or by virtue of Article 93 of the CISG? My short answer is no. I don't think Article 93 applies at all to this situation. The second issue, I will elaborate a little bit later. The second issue relates to the interaction between principles of public international law and relations domestic law, especially in the constitutional law. So if there are different or inconsistent requirements imposed on the one hand, principles of public international law, relations, international law obligations, and on the other hand, domestic constitutional law, what should we do? For example, if international law makes a different provision as Article 153 of the Basic Law of Hong Kong does, how should we resolve this discrepancy between public international law and domestic constitutional law? A matter which has been adverted to by Professor Wang in his speech. This is the second, in this second issue, I just want to look at two particular matters. One is about the legal effect of a declaration made by a state. If a state make a declaration to the world, to all other states, what will be the legal effect of such a declaration? The other issue is about Article 95 reservation. I know Professor Bill has already said a lot about this, and I agree with you about the reasons why we should not have such a reservation, but I will still add a little bit, a few more things on that point. So this is the second issue. The third issue, which is actually in the title of my presentation, that is we have a multilateral treaty. Can we extend such a treaty to basically interregional transactions? That's a transaction between parties from the same state, but they are from different systems of law. They are from different jurisdictions. How are we going to do that? Can we still apply the CISG as an international convention? That's the third question. So let's go back to the first question, Article 93. And I have said my view is that Article 93 doesn't apply to the case of Hong Kong. The reason is because, first, the clear words of Article 93. Article 93 says a state, when that state has two or more territorial units, at the time when the state joins the CISG, the state may make a declaration. Now, that requirement obviously is not satisfied here. The PRC, when the PRC joined the CISG, it might be, we may consider the time of signature, which was 1980 or 1981, and the time of approval, which is 1986. At that time, I don't think we can call Hong Kong as a territorial unit of the PRC within the meaning of Article 93. Okay, we don't argue with the other political issues whether Hong Kong is part of China. Hong Kong is part of China, but Hong Kong is not a territorial unit within the meaning of Article 93. So that means China could not, and China did not make a declaration. And a question arises whether China can make a new declaration at the time when Hong Kong returned to China in 1997. Some scholars believe, yes, Article 93 should be extended to such a situation which will allow the PRC to make a declaration. And because PRC didn't make a declaration, and therefore Article 93, Section 4 should apply, which means the CISG automatically extends to Hong Kong. I don't think that that reasoning is sound, and the primary reasons I would give first is that it will contradict the clear words of Article 93, Section 1, which requires and allows a state to make a declaration only at the time when the state joins the CISG. The second reason is because the PRC in 1997 sent a diplomatic note to the Secretary General of the United Nations, which is a depository of the CISG, which states very clearly CISG is one of those treaties which the PRC has not formed a decision, and the PRC will process later in the future. So, in other words, the PRC is saying that we still have the power to decide, but we want to decide in the future. You cannot interpret Article 3 or apply Article 3 in a way that will deprive the PRC of such an opportunity by saying that because that is not a declaration under Article 93, and therefore CISG automatically applies to Hong Kong. That will go counter to the clear intention evinced by a contracting state, the PRC. So that's the reason why I say that Article 3 was designed. If we look back at the history, the history and the legislative intention of Article 93, I think it's clear that Article 93 only applies to several federal states, which has two or more territorial units at the time when they joined the CISG. It did not extend to a situation where one contracting state later acquires a new territorial unit, which is the case of Hong Kong. So, otherwise, in other words, I don't think the problem can be resolved within the framework of CISG. We have to find a solution outside the CISG. And the solution is that we should just apply the general principles of public international law. So we are moving on to the second issue. That is, China can make a declaration, and that declaration can have legal effect under public international law if that declaration evinces a clear intention, and that intention has been accepted by all the contracting states. That's what I propose that the Central People's Government do by depositing diplomatic note with Secretary General of the UN saying clearly that the CISG will extend to Hong Kong with immediate effect. So that clear intention, unless any contracting state objects to that declaration, then it will take effect according to general principles of public international law. A related issue is about the Article 19.5 reservation. We have seen that it's probably not desirable for the PRC to keep the reservation, and there have been calls for its withdrawal. But that is not the matter we are going to deal with now. The question we are going to ask is, now Hong Kong need to consider, based on its own circumstances and needs, whether Article 95 reservation should apply to Hong Kong. If Hong Kong finds it's undesirable to apply the reservation in Hong Kong should make the case to the Central People's Government. And I can't see any reason why the Central People's Government will not respect such a request or will expressed by the Hong Kong government. According to the general principles and policies in mainland China, although it says that a reservation under an international treaty will, in principle, be extended to Hong Kong along with the treaty, but there are exceptions. The exception is if the reservation is made only in accordance with the particular circumstances of mainland China, and if it's unsuited for the circumstances of Hong Kong, and if by not extending it to Hong Kong, it will not infringe the sovereignty or fundamental interests of the PRC, then the Central People's Government can decide not to extend the reservation to Hong Kong, but only the treaty, not a reservation. And in this case, I think Article 95 reservation falls squarely within such an exception. And Central People's Government, I think, has every reason to agree the request made by Hong Kong, and it's very simple for Central People's Government to add in the declaration a sentence which says that the CISG will extend to Hong Kong, but the Article 95 reservation will have no effect in Hong Kong. I think by that way, if it's in Hong Kong's interests to keep the reservation away from Hong Kong, I think that's the right way to go. So let's come to the final issue. If the CISG is extended to Hong Kong, and Hong Kong need to implement this extension by passing a local legislation. And I think I agree in principle with the proposed bill in many aspects. For example, there is a clear provision which says CISG will prevail over the existing common law in the case of inconsistency. I think that's a very good provision that will bring the the application of CISG in Hong Kong in line with the application of CISG in mainland China. But there are some initial positions made by the Department of Justice, which I think may need to be reconsidered. One is the Article 95 reservation. The other is about the application of the CISG to a contract between parties with their respective places of business in mainland China and Hong Kong. So I call this mainland China, mainland Hong Kong contracts, or Hong Kong mainland contracts. Can we apply the CISG to such a contracts? Well, I think that if we want to apply the CISG to a regional contracts like that, because Hong Kong and China, mainland China, they are not different states. We cannot apply Article 1. And we cannot apply the CISG as an international convention by taking out Article 1 from CISG. If we remove Article 1 from CISG, the CISG ceases to be an international convention, which will impose international obligations on the national courts to apply the CISG. So in effect, I think what will happen is that Hong Kong and mainland China should seek to apply CISG not as an international convention, but as a set of neutral rules. This set of neutral rules will exclude Article 1 and also all the final provisions of CISG, but will consist of the rest of the convention. And this set of rules will be applied to Hong Kong mainland contracts, not by virtue of any international treaty, not by virtue of any international commitment made by PRC, but by virtue of a bilateral agreement between mainland China and Hong Kong, and also the respective implementation measures taken by the government in Hong Kong and in mainland China. Why the bilateral agreement? Well, I think that the reason is because it's not beneficial to Hong Kong to do it unilaterally. Well, you need the Chinese courts also apply the CISG to a contract between Hong Kong party and the mainland party. Otherwise, it's a one-side favor. It should be a mutual treatment. And that bilateral agreement, as as Mr. Wang already mentioned, there are some previous examples which could be used as a template for such an agreement. For example, the arrangement for the mutual enforcement of arbitral awards reached between the Hong Kong government and mainland government will be an example. And the normal practice is for the top judicial organs on both sides to reach agreement. And as a result, in Hong Kong, on the Hong Kong side, there will be local legislation. But I think the local legislation should spell it out that the CISG, certain rules of the CISG will apply to Hong Kong mainland contracts as a set of neutral rules, not as an international convention. And on the mainland side, the normal practice is for the Supreme People's Court to issue a document. I would say in this case, we should persuade the Supreme People's Court to issue a judicial interpretation, which has a formal legal binding force in China, to order all courts to apply CISG or certain provisions of CISG to Hong Kong mainland contracts. From the date when it's effective. I think that's the way to go. I think that's the way how you make the CISG applicable to Hong Kong mainland contracts. And we have prior experience to fall back on, and we have the implementation measures, facilities in place to make this happen. And the reason why we want to make CISG apply to Hong Kong mainland contracts is because if we go back to the economic case made by the Department of Justice, we will see that much of the force of that argument lies in the trade between mainland China and Hong Kong. It's more than half of the total trade of Hong Kong. If we are going to make an economic case for the extension of CISG to Hong Kong, then that case will lose much of its force if we do not extend the CISG to Hong Kong mainland contracts. So that's the end of my presentation.